I don't want to deride our trial lawyer brothers and sisters, but it seems to me that what you just described is sort of a skill set that we develop as appellate lawyers. And the ability, and appellate judges, I would add, the ability to cut through the fluff and see what's really important. Because I tell folks all the time, it's like, look, you probably have maybe 3 decent issues in your case.
That's right.
And if you're arguing that 4th, 5th, 6th issue, if you think that's the one that's going to get you relief, you're sadly mistaken. And I mean, I'd love to hear, your perspective on that. That's kind of my, that's in my hip pocket for almost every client. It's like, look, you may think that the judge did all these things wrong. But at the end of the day, there's only going to be a handful of things that could get you the relief you want if we persuade the Court of Appeals to go with us on those.
That's
because, people are still get hung up on evidentiary issues. And I say, look, admitting or excluding evidence is almost never going to lead anywhere. You spin your wheels. And to me, it's really important in this day and age when we've got to be as efficient as we possibly can be in handling an appeal. It really should, as you're suggesting, trickle down to the trial level. And that, I think, is where folks like the 3 of us really can help and I'm glad to say that I've got, lawyer clients who know this about me, that, you're going to be able to cut through the fluff, Todd. You're going to be able to see the things that are important. And so that, it sounds like that was kind of the case in that Philadelphia trial, where the lawyers were they lost, seeing the forest for the trees, and are arguing about the minutia that in the end just really doesn't matter.
No, it's so hard to convince some lawyers of that. But what I've found are the really good trial attorneys understand that having an appellate attorney involved in the trial level helps exactly with what you're saying. Cutting through the issues that don't really matter, streamlining things. It's kind of like the old adage, the old advice a lot of trial lawyers used to give, doing the jury charge first. No one really does that, unfortunately, because clients usually won't pay for it. But having an appellate lawyer involved at the trial level is exactly that in some ways. It's like having the jury charge done already. Well, of course, by the time we get in, sometimes it is. But it's that bringing that view of, well, look, why are you worried about this issue? Because that doesn't answer the question the jury's going to be asked. It's that kind of thinking. And then, of course, honing in on the legal issues that really helps. And as you know, Todd, I mean, even when I was trying cases, I would always have someone else there worrying about the jury charge. And because my view was, if you're trying the case, you ought to be focused on the witnesses and the jury and judge, and let someone else worry about the legal issues. And then, of course, we've all played the role of appellate attorney as well. And it's a great 1-2 punch, but a lot of lawyers out there don't realize it. A lot of clients don't realize it, or aren't willing to pay for it.
You mentioned dealing with the jury charge. What I tell trial lawyers is, you're about to make your closing argument. You need to be focused 100% on your closing argument. This is the point in the trial where you get to, wrap it all up and tie it up with a bow and tell the jury exactly what you want them to do. Do you really want to shift from arguing this minute point of an instruction and a jury charge to 10 minutes later, making your jury argument? And I know it's one of the reasons why I didn't excel at trial work, was that I couldn't make that mental shift that quickly. Some people, I think, can, but it's just tough.
It's extremely hard to do that. It really is. It's just a different skill set. And even if you can do it, the question is, should you be doing it?